The broadcast is now starting. All attendees are in listen-only mode.
Good morning, everyone, and thank you for attending and welcome to the stakeholder meeting for the Office of Hearing Aid Provider Licensure. Before we get started this morning, I'd like to introduce staff members from the Division of Professions and Occupations that are present to help facilitate the meeting. I'm Karen McGovern. I'm the Deputy Division Director of Legal Affairs for the Division of Professions and Occupations. And with me today are Laura Bravo, a policy analyst for the Division of Professions and Occupations, and Zen Mayhew, the Program Director for the Office of Hearing Aid Provider Licensure. In compliance with governor's orders regarding COVID-19, we have transitioned to a platform that is 100% virtual, and we appreciate your flexibility. As we move into the stakeholder meeting today, I want to reiterate the importance of your feedback. We make decisions every day that affect your life and your business, and your input is vital in the rulemaking process. Throughout this process of rulemaking and stakeholder engagement, our goal is to create regulations that clarify and explain legislation, ensure minimum competency to enter and continue practice, and to provide only that regulation that's absolutely necessary for consumer protection without creating unnecessary barriers to the marketplace. Today, we're going to focus specifically on Colorado House Bill 20-1218, which is the sunset review of hearing aid providers. We're also going to speak a bit about House Bill 20-1326, which is the Occupational Credential Portability Program, and Colorado Senate Bill 20-102, which requires providers to disclose discipline of convictions of sexual offenses. So the process for our meeting today as we move forward, first I want to let everyone know that the meeting will be recorded and it will be posted on the website in the next couple of days. Because we're holding this meeting entirely by webinar, if you want to provide feedback, you can use the hand icon if you'd like to speak. And when we see that your hand is raised, we will unmute your line so that you can provide your comments. If you don't want to speak on the webinar, there's also an option for you to type your comments or questions into the question section. Once we receive that question, we will read it aloud so that everyone has the opportunity to hear your feedback, or so that we can provide an answer to your question. If you are going to either participate by providing your comments through the webinar orally, or if you're going to write them out, we ask that you state your name and who you represent. We encourage comments, general comments on the rules, rule changes that you think are necessary to implement the legislation, or if you have specific comments on proposed language. We're not going to be really strict with limiting comments today. Looks like we have a pretty small group, but just if you can be mindful when you're speaking that we want to give everyone an opportunity to participate. If you're using the audio through your computer, please remember to put any phones on vibrate or mute so that they're not disruptive of the conversation. Also, make sure that when you are speaking when you're speaking during the webinar, if you can keep background noise to a minimum, we can get a lot of feedback through this platform, and so it's just easier for everyone to hear if we try to minimize background noise. I think we will start with the occupational credential portability legislation, and that is House Bill 1326. What that bill does is it streamlines licensure by endorsement. So for people who hold a license in another state and who are coming into Colorado are able to use a license from another state to qualify for licensure in Colorado. That endorsement has been in place for quite some time. This new portability program, which is called the Red Tape Reduction Act, calls for the division to streamline processes and make sure that that each program is not adding unnecessary burden to that process. The next bill is Senate Bill 20-102. In that bill, it requires all healthcare practitioners that are subject to reporting to the Health Professional Profile Program under the Michael Skolnick Transparency Act for any healthcare professional that meets that criteria, which does include licensees of the Office of Hearing Aid Providers, requires that those providers make disclosures to their clients or patients prior to providing professional services if they have a conviction of a sex assault through a court of law. So a conviction will also include a guilty plea. If they are currently serving a sentence, that could be probation or parole, as a part of that criminal case, they are required to disclose that to their patient or client. Similarly, if the licensee is subject to professional discipline on his or her license, for sexual misconduct, then they are also required to make that disclosure to their patient or client prior to providing professional services. Once the disclosure is made in writing to the patient or client has to acknowledge receipt of the disclosure and affirmatively agree to treatment by that provider. Once that provider completes their criminal sentence or their professional disciplinary probationary term, or that may include restrictions on their license, once they have successfully completed that, then they are no longer required to make the disclosure. And we'll talk a little bit more about that when we get to the rules. And then the other bill we want to talk about is the sunset review of hearing aid providers. And I'm going to put this one up on my screen so that you can see it. And this is House Bill 20-1218. Just going to go through and highlight some of the bigger changes so that everyone's aware. Going down through the bill, one of the big changes that I think we need to flag is under scope of practice. So the scope of practice for hearing aid providers includes prescribing, selecting, and fitting appropriate hearing instruments and assistive devices, including appropriate technology, electroacoustic targets, programming parameters, and special applications. The language that's highlighted in yellow was added to the Act, which says that either the initial testing or the first fitting must be performed in person. And so that is a change to the Act, and I wanted to make sure to highlight that for you as we go through this. For title protection, they did add additional title protection for hearing aid providers, saying that a person who's not licensed can't use any other title that implies the person is qualified as a hearing aid provider. They did add a section here to what activities require a license, and in section B it says directly or indirectly selling or negotiating to sell any hearing aid for the hearing impaired. So that was added. So any activity that involves this requires a license. As you go down here, it talks about in order to qualify for licensure. Previously, the statute called out the National Board for Certification in Hearing Instrument Services as the national competency examination. They've removed that from the statute. That isn't specific to your profession. This is a trend we're seeing over at the legislature, is taking the names of the organizations out of the statute and then asking the director to determine that by rule, so that the regulator can be more nimble if the body that's doing the certification changes during the term of the statute. The next piece that is new is that financial assurance is now required for hearing aid providers. So prior to being issued a license, The applicant has to post a surety bond in the amount of $10,000. They need to maintain a $1 million professional liability policy or comply with an alternate as determined by the director, and that's certainly something we can talk about today. The licensed hearing aid provider has to maintain the required bond and policy or alternate at all times. So it's not something that you just need to get your license, it's something that you have to maintain as a condition of licensure. Continuing education was added. The statute now requires that each licensed hearing aid provider in active practice has to annually attend not less than 8 hours of continuing education on subjects related to the scope of practice for hearing aid providers. Under grounds for discipline, an additional ground was added, which includes failing to practice according to commonly accepted professional standards. It also added a provision that says if, as a hearing aid provider, you were disciplined in another jurisdiction, that discipline on just that piece of discipline constitutes prima facie evidence of grounds for disciplinary action, including denial of a license under this article. But making sure that you look at the exception, it applies only to discipline for acts or omissions that are substantially similar to the grounds for discipline in Colorado. And then looking at section 12-23501, deceptive trade practices, it defines a dispenser for the purpose of deceptive trade practices and defines that as a person licensed as a hearing aid provider. And when you go through this definition, when they talk about what constitutes deceptive trade practice, they have a lot of, there's a lot of clarity added in the statute. It's actually very precise. I think one of the big things that I do want to point out is that there are requirements to be placed on the receipt for every hearing aid provider sale, and I think that that's important and something that we may want to think about when thinking about perhaps maybe a model receipt to make sure that the licensees are in getting the required information in the written receipt or contract. Talks about the right to cancel, talks about refunding, talks about dates when the contract has to be completed. And so just making sure that as licensees that you are familiarizing yourself with the requirements of the Deceptive Trade Practice Act, understanding that now you will be required to comply with all of these new terms and conditions. So with that, I'm going to open it up for any comments that the stakeholders have right now while I switch my screen over to the draft rules.
Okay, thank you, Karen. If anyone, feel free to raise your hand or submit your written comments in the questions area of your screen. Okay, I have a hand raised from Randy Holyfield. Randy, your line's unmuted. Go ahead.
Hi, this is Randy Holyfield. Can you hear me okay?
Go ahead.
Okay, just wanted to make sure you could hear me. I am the, are you hearing me?
Yes, go ahead.
Oh, okay, sorry. So I am the Government Affairs Chair for Colorado Hearing Society. We are the group that worked with Vivian Belmont and the analyst from Dora, and then also the legislature in helping craft some of the language. So I didn't know if you wanted to go over any of the specific points or history on this. We're very much in support of these rules and regulations, especially the areas that were highlighted. I don't know if we want to talk about anything as far as any clarity that Dora could use in trying to understand, how Office of Professional Licensing could impact this. So I'm just not sure how we can help provide some guidance, but since we're very closely tied to the hearing profession and we're the group that represents the hearing aid licensed professionals in the state of Colorado, we would be available to your office for that. Things like the national competency exam from national boards and NBCHIS. Right now, there is not an outside or alternative agency for that. So dropping the language of NBCHIS, I understand, was for the benefit of, in case they organizationally change their name, you don't have to change your language. But presently, that is the organization that represents the board certification competency exam. I think you're scrolling through, so if you want to continue going down the pages, maybe to any area that was highlighted in yellow, we could just kind of look at that and just talk that out.
Sure. I mean, if you have specific feedback that you want to add, I've changed my screen over to the proposed rules. And so certainly happy. I mean, this is really for us. This is an opportunity for you to provide us with the information you want us to know. So I don't really have any specific questions, but happy to address any concerns you have and what you would like to see in the rule based on the changes made at the legislature.
We're very comfortable with those changes. I just want to make sure that we're kind of, I guess, tracking on the same page. So, for example, the area of the surety bond,
Yes.
Perhaps just as I was hearing it being presented, I just want to make sure that we understand that it is a $10,000 surety bond, comma, or a $1 million professional liability policy, comma, or as established by the director. So it's not the combination of a surety bond and $1 million liability policy. The one or the other of those addresses that issue. And generally speaking, the reason that's practical is sometimes it's just difficult to find people willing to write surety bonds. Not that it's onerous, it's just sometimes difficult to find organizations to do it. And where most of us are working with third-party insurance providers, United Healthcare, Humana, Cigna, Aetna, if you're going to be a provider in their network, they almost all require at a minimum $1 million surety bond. I'm sorry, $1 million professional liability policy. So it's consistent with most professional practices to already have that in place. So we didn't feel that that was going to be in any way onerous to the majority of the profession. So
Sure.
That's why that amendment took place.
Okay. And so then I'm interested. Okay, go ahead.
So the other piece that was probably most noticeable was the addition or inclusion of the continuing education hours. And the reason we felt that was important is not only just the obvious constant changing of computerized technology and wireless capability and made for smartphone capability, but also just the fact that originally in licensure, you mostly came into being a hearing aid professional in Colorado by having your 2-year board certification from NBCHIS. And to maintain your boards, you had to have a minimum of 10 hours a year of continuing education. So we didn't have continuing ed in Colorado licensing, but by de facto we did, because you had to have your continuing ed to maintain your national boards. Then we changed, or we added another licensing process of just 300 hours of training, taken the ILE exam from IHS, no practical examination, and you're now licensed. And so we felt that we kind of lost what we had in place with continuing education. And so we were very pleased to see that continuing education really get added back in when it really had been there, but just not specifically in our Practice Act. So that's kind of the inclusion of continuing education, to just kind of add it back in when it kind of existed before.
Okay. Thank you. Really appreciate that.
Yeah.
Laura, do we have any other stakeholder comments?
We do not at this time.
Okay, so I think we can just sort of kind of go down through the rules. So for Rule 1.1 for original licensure, the rule for hearing aid providers already included the exam, so there's no addition needed. It was already contained in the rule as well as the statute. Making sure that we put in the requirements for licensure, that the requirement for the surety bond or the liability insurance. As we look at that space, are there any suggested alternatives that stakeholders would like the director to consider, since the rule does allow the director to consider alternatives to the surety bond or the liability insurance?
If anyone would like to comment on that, feel free to raise your hand or send in a written comment or question in the questions pane. Okay. Randy Holyfield, go ahead.
Thank you. So since we've dropped the specific language later or earlier in the legislature about the BCHIS, are you just going to carry that same change over to just refer to the national competency exam, but not specifically the national boards? Or since that is specifically, at least today, the one and only national competency exam? So
so essentially,
how do you think that'll read?
So essentially, the trend in the legislature has been that they are taking the name of the certifying or testing agency out of the statute. And for most of our professions, so in this instance, hearing aid providers is not unique. For many of our professions, there is only one agency or one organization that provides the test, but we still do clarify that in rule, because there could be a test out there that we don't know about. And so we want to make sure that it's clear to the people who are applying to our state what test we require. So does that make sense?
Makes sense. Yeah. Okay. It does.
Okay.
Yeah, thank you.
Great. And then did we have any comments about the alternates to the surety bond or liability insurance?
I don't see anything at this time.
Okay. So the next rule I think we can look at is licensure by endorsement. And that rule is directly related to the Colorado House Bill 2013-26 that I mentioned, that talked about clarifying licensure by endorsement and that red tape reduction piece. So you can see the changes to the rule. The first thing is that we changed the statutory citation. The requirements under the Red Tape Reduction Act are that the person applying has an active license in good standing in another state or territory of the United States or a foreign country. So that is unchanged from the previous law. It's been historically, it's been required through endorsement that the person has to present proof to the director that the license they have in another state was issued based on substantially equivalent qualifications, as we require in Colorado. The Red Tape Reduction Act is quite similar. It just changes the wording. So instead of saying qualifications, it now says that we have to make sure that the experience and credentials are substantially equivalent to those for Colorado licensure. And then it requires that the director or the board determine what substantially equivalent means and how that can be determined. And so here, through rule, the hearing aid providers had decided early on that substantially equivalent included earning a degree with a concentration in hearing aid fitting, dispensing, or completed supervised training to do so, and that they passed an acceptable entry-level examination or obtained a certificate of competency in hearing aid fitting and dispensing. Does anybody have any feedback about that? Does anybody think that demonstrates the substantially equivalent experience? The director also allows a couple of other pathways, so substituting active practice, and also looking at military service. So I'm interested if anybody has any feedback on this piece.
Okay, we have a hand raised from Randy Holyfield. Go ahead.
Thank you. This is very much what we had in place before and didn't pose any issues. We did get the military time as an addition to the Practice Act added, I think, within the last few years. So it's good that this is being consistent with that. I'm just not quite sure on point number B, point 2, what a certificate of competency in hearing aid fitting and dispensing, I don't know what that would be, since there's no mention as to what would be the organization or institution providing that competency. I don't know how we determine what that is. Typically, we've used the International Hearing Society's ILE exam for the most part throughout most of the states, Colorado being one of them. And there are a few community colleges across the country in the U.S. that provide or offer an AA degree in hearing aid dispensing and fitting. There's only a few of them, but I don't know what that certificate of competency would represent. So that one I'm just not sure of.
Okay, fair enough. We can look at that. I think when we look at these rules, we want to make sure that we're including any language that other states might use, so that we can make sure that people understand that we're going to look at their credentials and make a decision, and they shouldn't feel like they can't apply because they don't have the title of their certificate or the title of their degree doesn't exactly match. And so that may be why that language is in there, but I'll certainly check it out.
Yeah, that makes sense. I mean, yeah, we're not looking to basically keep someone who's competent and qualified to basically apply and become a dispenser. I just also don't want someone to go, yeah, I took a class someplace and I got this certificate and it says I'm competent, and usually it's a competency in perhaps the actual fitting software of that particular manufacturer, but it doesn't represent basically any degree of competency in the profession. So I just wouldn't want too much ambiguity when it comes to something that I'm not quite sure what that would be.
Sure. Is there, while we're looking at this, is there space for, or is there an organization that allows or that grants certification for hearing aid providers?
Not that I can think of. Again, the ILE exam, IHS, the national boards, and then everything else I can think of in my profession when it comes to certificates I have on the wall are going to be very specific to that manufacturer's fitting software. I can't think of anything that would be representative of comprehensive knowledge in the industry. There's tinnitus certificates. There's the master's level program I have for audio prosthology, but it's kind of advanced education, but still not when it comes down to the actual demonstration of competency as a hearing aid dispenser.
Okay, thank you.
Thank you.
So we go through here, none of the changes to through the Practice Act would affect Rule 1.3. Certainly if somebody has comments about that, please feel free to type in a question or raise your hand. Looking down for licensed associates, requirements for reinstatement. Is there a place here in this requirement for reinstatement that because now there are required continuing education, oftentimes when people are required then to reinstate a license that's been expired, then typically they will ask for them to do their continuing education. And it looks here that if a license has been expired for more than 2 years, then the licensee could demonstrate competency to practice by completion of 30 hours of continuing education. So that would be 15 hours a year, which would be really double the requirement for an active licensee. So wondering what stakeholders feel about that. Do you think that that is appropriate? Should the completion be 16 hours? Or should it be 16 hours for the 2 years preceding the application? Or do you feel like because it's a reinstatement that it's okay to require those additional hours?
Randy Holyfield, go ahead.
So this is Randy Holyfield. I wouldn't see a reason to penalize someone by requiring extra hours of continuing education for the period they were not carrying it. I think if it would just be consistent with someone who is maintaining their license actively, I wouldn't.
Okay.
I wouldn't want to put a stick on them, a hammer. I just would be happy that they're back and helping individuals. Okay. And for example, I'm licensed in multiple states, but not practicing anywhere outside of Colorado. I maintain my hours. So just because I'm not practicing in California, I still maintain my continuing education. So it wouldn't be burdensome for me if I wanted to renew my California license actively, or Colorado if I was outside, to basically be able to come to the table with the equivalent of 8 hours a year of that.
Okay.
Okay. Thank you. If anybody else has any comments or questions or thoughts, feel free to raise your hand or submit something in writing via the questions area. I don't see anything at this time.
We have the requirement to have a plan for customer records and maintaining the records. And that's consistent with the statute. Wondering if anybody has any questions about or any thoughts about adding the requirements from the deceptive trade practice in here. Okay. written disclosures to purchasers. It looks like pursuant to some other statutes that there were already requirements for disclosure. And there's already a section here that requires provisions on all contracts that state the following. We did add the proof of bond or liability insurance, that's available upon that, a copy of that policy is available upon request to the customer. Wondering if we need to add, or what you guys think about adding here, the requirements of the deceptive trade practice. Sometimes licensees like to see that at least referenced in the rule, so they have it in one place, and I'm interested in your feedback.
Mr. Horsell, go ahead.
Thank you. When I originally created our purchase agreement contracts, we went to Dora's sample and actually used that verbatim for our forms.
Okay.
And so I think earlier, Karen, you mentioned that you might consider putting or posting or creating kind of a sample or an example. And I think that would be great, because most of us don't want to hire attorneys to basically be sure that we're in compliance, when really we would rather just say, if this is what you want presented to the consumers, then I'm happy with that.
Okay.
I don't know, though. I'm trying to think of just the logistics of it. That someone in my office, we're talking about hearing instruments. They want to go ahead and proceed with purchasing. We have our contracts and forms. And then we're going to have things like, am I stating that I can provide proof of a surety bond or my insurance license?
Yes,
or what in that? Yeah.
I think it's just a statement in the contract that says proof of bond or liability insurance is available upon request. Basically, you're just letting them know that if they want to see it, you can show it to them.
Okay.
Okay.
How are we providing that proof to the state? I realize it would usually only be when there's a complaint or something like that. It's probably not, proactively provided. It's reactively. But should we make mention of the fact that information is available not just to the consumer, but to the appropriate state agency?
I think in the disclosure, you can make it. You just need to make it. I think that the point of the disclosure is advising the consumer, and I'm not sure that you necessarily have to tell them that you would have to show it to us. Typically, when you look at our license, our original licenses and renewals, we will ask for documents that we need. I would say for our other programs where there's a surety bond required, we require that the applicant or the licensee attest under penalty of perjury that they have the appropriate bond in place, and that they're required to provide proof of that bond upon request of director. And so just as you said, if we get a complaint, then we will always, I won't say always, but I would say 99% of the time we're asking for proof of the surety. And here, there's an alternative, so it would just be proof of the bond or the liability insurance. Okay. Going down now, the changes to the Practice Act don't really have any, make any changes to the duty to report convictions or adverse actions. Doesn't really change the duty to report information to the director. Wouldn't change your rule on declaratory orders. Wouldn't change the credit for military education, training, or experience. Is not going to make a change to the new rule that you have about out-of-network providers. And then I think the big change would be the addition of a completely new rule. And this new rule will be required as part of Senate Bill 20-102, which is the new mandatory disclosure for those licensees that have a conviction or a plea of guilty to a sexual assault, or if their professional license is subject to probation or terms and conditions as a result of the board finding unprofessional conduct based on sexual misconduct. So starting on March 1st, 2021, all licensees that are in this circumstance will be required to make the written disclosure. This rule goes through and talks about the form of disclosure, that it has to be written. There is an appendix at the end. I'll shoot there right now so you can see it. Appendix B, and it is the model sexual misconduct disclosure statement. So it sets out everything that has to be in that disclosure, so that to help the licensees make sure that that disclosure is written appropriately. So that's when you talk about the form of the disclosure, that's what that is. The timing of the disclosure, the law requires that it has to be provided to the patient the same day the patient schedules the professional service appointment. In those instances where an appointment is scheduled the same day of the service, or if an appointment is not necessary for walk-ins, then the disclosure must be provided in advance of the treatment. The written disclosure has to be completed prior to each treatment appointment, unless it's a series of treatment appointments. So if you have the situation where they're coming back for fittings over and over, and you're seeing them in a period of, 6 or 7 weeks or 3 weeks, and they're going to keep coming back for fittings or testing, then you only need to make that disclosure once, unless the circumstances change. So if, say, the terms of your probation changed since the last time you saw the patient. The one piece that I think is particularly important to note is that once you have successfully completed your criminal sentence, whether that be probation or parole, then you no longer have to make the disclosure to the patient or the client. The same thing goes if you're making the disclosure because of a professional licensing issue. Once you've successfully completed the terms and your license is returned to active unrestricted status, you don't have to make that disclosure anymore. And then there's a whole host of exceptions. So if the patient is unconscious or is otherwise unable to comprehend the disclosure, and they are not accompanied by a guardian, then the disclosure is not required. I would say making sure, just in your profession, when we talk about otherwise unable to comprehend, that wouldn't include hearing impaired. And so just making sure that that's clear. When they talk about otherwise unable to comprehend, they're talking about a cognitive issue or someone who's unconscious. If a patient visits an emergency room, freestanding emergency department, or if the visit happens in an inpatient facility, if the licensee is providing services to the patient and they don't know the patient until immediately prior to starting the visit. And I think this exception was put in place for professions such as surgical assisting and technology, when they can be assigned to a case while the patient has already been moved to the operating room. similar to emergency room doctors or anesthesiologists, a trauma surgeon who wouldn't meet the patient before they started surgery. And then if the licensee does not have a direct treatment relationship or direct contact with the patient, and I think this exception was put in place. If you think about pharmacists who are filling prescriptions, sometimes at a site that's distant from the patient and they have no patient contact. Does anyone have questions about this new rule? Comments, feedback?
Mr. Holyfield, go ahead.
This is Randy. I don't know that I have anything specific because it's hard for me to imagine this coming up too frequently, but it sounds like, first of all, office staff is not participating in this. This is only the licensed professionals. And we're just keep in mind the nature of our industry is we have a lifetime relationship with that client unless they go someplace else to buy a new set of hearing instruments. So we'll see them in a short period of time, probably several times in the first month and then many times in the first year, but then periodically we'll see them continuously forever. So we do have that continuity relationship. Almost all patients are making appointments remotely. They may occasionally walk into the office, but probably not very many occasions where they're making an appointment for same day. Not sure how I deliver, not me, but how someone would deliver that notification to someone who's phone called. Are you talking about an email notification, a physical mail notification? I'm just trying to wonder.
I think it can be handled.
How they comply.
I think that can be handled either way. I mean, I think when you talk about making appointments remotely with healthcare professionals, oftentimes, you can download your paperwork to fill out online and submit. So whether it's you're asking for their email address at the time they make the appointment, so you can send them the disclosure so that they can sign it and bring it with them or send it back to you. Certainly you could mail it out to them, but I think it's, making sure that in the practice that there's a plan in place to handle these disclosures.
Yeah. Well, we wouldn't be dealing with anyone unconscious, but certainly cognitive challenges would apply.
Sure.
Someone could come in with dementia or Alzheimer's and be in the presence of like a family member or a caregiver. So that's very applicable.
Okay. So does anybody else have any comments? Go ahead.
Karen, can you close your stakeholder Google Calendar reminder? It's just, I think it's on your screen, not mine. So it's just kind of covering up some of the language at the bottom. Thank you. That's all.
Does anybody else have any comments or questions about the rules as we've gone through? Now would be the time to put those out there. If not, I can talk about next steps.
And no written comments right now.
Okay. So as we move forward, making sure that we're all on the same page as it relates to events. This matter is scheduled for a rulemaking hearing. Excuse me, I'm trying to work through my screen here to get down to my schedule for rulemaking. The rulemaking hearing for these rules is September 30th at 3:30 p.m. It will be virtual. It will be on the same platform. We will send out, I will take these rules back to the director. We will make any revisions that are necessary and then send you a copy of the proposed rules with the notice of the stakeholder meeting. We will send that to all licensees and stakeholders who are listed on the stakeholder list. And we will make sure to send you the link so that you have a link to the webinar. These rules will be posted with the Secretary of State on Monday, and so those will also go out in the register on September 15th. Does anybody have questions about next steps? Okay. Well,
I don't see anything in writing, and go ahead.
Okay.
We're all good.
All right. I want to thank everyone for your participation today. I really appreciate the time, and make sure if you have any questions, you can reach out directly to Dora, D-O-R-A _DPO _rulemaking at state.co.us. You can send questions there. You can provide written feedback. If you have questions, we will reach back out to you and get those questions answered. So again, thank you a lot for participating and for your time. Have a good day, everybody.